your host, Alan Storman. Mr. Storman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now, we introduce our guests and our host, Alan Storman.
Welcome to Lawline. The federal sentencing guidelines have had its share of critics since taking effect in 1987. Today we'll look at the pros and cons of sentencing guidelines and see what impact they have had on the criminal justice system. Our guests are the Honorable Shira Shinlin, United States District Judge, Southern District; Matthew Fishbein, Chief Assistant United States Attorney, Southern District; and Gerald Lefcourt, President-elect of the National Association of Criminal Defense Lawyers. Hello, Judge Shinlin, Jerry, Matt. Judge, give us an idea. Sentencing guidelines. What's all this talk about?
Well, there's a 2-volume book, and it tells us how we have to sentence people. You know, there was once upon a time when a judge would look at a defendant, figure it out for themselves, come up with the right sentence, and sentence somebody. But now there's a book, and you have to look in that book, and you look on a chart, and all of a sudden the chart tells you the range that you have to apply. So a judge's discretion is now much more limited than it once was in sentencing a defendant. And that's a short answer.
Judge, give us a personal view. How do you personally feel about these sentencing guidelines?
Well, there's good and there's bad. I do want to make that point. The good part is there's some guidance. There's a range. There's a comparative way of knowing if you're sort of in the right ballpark. On the other hand, you're very limited now. You can't just do what you think is right. You have to do what Congress thinks is right, and you have some play within the system. And it's a big challenge to use your creativity and ingenuity to try to do what you think is right within the structure of the guidelines. So there is a challenge left.
Now, Matt, you're representing the United States Attorney's Office. You're the Assistant Chief U.S. Attorney, Southern District.
Right.
How do you feel about the guidelines?
Well, I guess I also think there's good and bad. I would say at the outset I was a strong proponent of the guidelines because one of the things that always bothered me about sentencing was that under the old system there would be a tremendous disparity between sentences of different judges, and depending on what judge you drew, you could get a very different sentence.
As well as different locales. Texas, you could be sentenced one way. New York, perhaps a different way.
Right, but particularly even within the same courthouse, if you drew one judge, you might get a 30-year sentence for a particular crime. Another judge might have a 2-year sentence.
That large a difference?
Yes, I mean, that's unusual to have one that large, but not unusual that there would be significant differences. So I saw the sentencing guidelines as a way of trying to get a more consistent application of the sentencing laws to similarly situated defendants. The problem is that under the grid that we now use, I mean, there are still results which appear to be, in some cases, somewhat arbitrary or unfair, and I think that is probably a view that we all share in various respects, prosecutors, defense attorneys, and judges. And so what's happened is it's not that certain that there really is a more meaningful result than under the old system, and what's resulted now is tremendous litigation, which really ties the system up in knots. Litigation both before sentencing and negotiations between the prosecution and the defense, litigation at sentencing in court, and then on appeal. So there's a whole range of work now in our office which is taken up just on sentencing guideline issues which never existed beforehand.
And Jerry, from a defense standpoint, from the actual client who maybe is charged for the first time with a white-collar crime, what's the story there?
It's a very unfair system from the defense point of view, because you may have a client who is deserving of a small sentence, but notwithstanding the client's background or his role in the offense, the judge is powerless to impose the kind of sentence a particular judge feel is just. The power has shifted from Judge Shinlin to Matt Fishbein. And everybody in the criminal justice system knows that what Congress did was tie the hands of the judges and give tremendous power to the prosecutors. The purpose of the sentencing guidelines was to eliminate the disparity that Matt talked about a while ago. And now it's not who the judge is, it's who the prosecutor is. And it could be even in the same building. Different prosecutors who have different temperaments, different views, can end up working a case with a defense lawyer so that the sentencing could be vastly different. And it's really now in the power of the prosecutor. One of the great ways they exercise this power is by defendants cooperating with the government. The disparity now, it's up to Matt, for instance, whether a vicious drug dealer does 20 years, which may be a mandatory minimum, and there are mandatory minimum sentences all over the place, or maybe does a year or so. It's up to him. If he wants to tell Judge Shinlin that this person has really cooperated wonderfully with the United States Attorney's Office and go to bat for that person, he could get the person little or no time.
Matt, is that correct?
Not entirely.
But mostly.
It's certainly
99%?
it's certainly it's within our sole discretion whether to make a motion to the court to allow the court to depart from the sentencing guidelines on the basis of cooperation. And if we decide that someone who has attempted to cooperate has been unsuccessful, either because they've lied or because they haven't rendered substantial assistance to the government, we won't make that motion, and the judge will not be able to depart on that basis.
So it's within Matt's power to decide that.
But once we make the motion, the range of departure is entirely up to the judge. And we're also, we have to act in good faith, and in instances where defense attorneys think that we haven't acted in good faith, they've made motions before the court to enforce agreements even where we haven't brought the motion. So we are held to a good faith standard, and certainly, we have to follow. Go ahead.
Can I jump in here? I thought, Jerry, you were a little too strong. I don't feel like my hands are tied. As you see, they're moving all about. We still have the power to depart downward. And the Supreme Court has recently told us they're going to review that on an abuse of discretion standard. And it was an interesting case, and the court there came up with 6 different reasons to depart downward, and 4 of the 6 were upheld. So it depends.
Kuhn case.
Yeah, and it
Stacey
depends on your advocacy. If you can advocate,
But you know what the problem is?
if you can advocate some good reasons for departing downward, and you've got a receptive judge, there's a shot of that. Now, he asked you a question about white-collar crime, and you started talking about mandatory minimums. I don't know any mandatory minimums. I mean, most
Well, there are mandatory minimums in white-collar crime, too, now.
Okay, but typically we think of them in the narcotics area. I think that's really where they're bothersome. But in a typical white-collar case, it seems to me you've got a first offender, you've got many arguments to make on downward departure, and your we want your advocacy. I'm very receptive to your advocacy.
I have a white-collar crime,
Right.
and you're a new judge who I have great respect for. But Matt and I appeared in front of a judge not too long ago, and I don't want to mention the judge's name or the case because it's not appropriate, where the judge wanted to give a lower sentence than the guidelines called for. And the judge actually issued such a sentence. And the prosecutor in the case, Matt's office, and Matt personally, said, no, we don't think that's right, and we're going to appeal you if you do. Now, not every judge is as brave as you are. And so that judge had a private meeting with Matt and I. And that judge actually looked at Matt and said, please, I'm not comfortable with this sentence, in almost a pleading manner. Please, I usually do the right thing. In this particular case, I'd like to impose this sentence. And it was the judge
What did the judge
looking at what are the
What did the judge want? Don't appeal? Is that what the judge was trying
the
to say?
judge didn't want to be appealed.
This case, in some ways, illustrates why the sentencing guidelines were needed and why.
But that happened, right? I mean, it's a funny thing.
It happened.
It's a new world.
It's a situation where the judge recognized that she had no legal grounds for departure and felt, nevertheless, that she wanted to depart. Now, the sentencing guidelines, one of the reasons they were adopted and what they were intended to address was just such a situation, that because of a judge's personal feelings about a case or a defendant, a judge might this particular judge might decide to award a more lenient sentence or perhaps a more severe
Because
sentence.
of a first-time offender,
Yes.
or because of the nature of the offense, or something of that
all
nature?
that was true.
But the nature of the offense and the first-time offender are factored into the guidelines. There are different...
That was done in Washington by...
Right, so what that means is they're not permitted grounds to depart downward because they were already considered by the commission.
Correct.
And then if the judge does it, then the U.S. Attorney just could appeal to the
correct.
U.S. Court of Appeals
That's correct.
and have the sentence, I assume,
right.
upgraded
And
to a higher
what this
sentence.
judge
So
was
here
saying-
you
what
have
this-
the bizarre
except
result.
what this judge was saying in this case was, I recognize that there are no appropriate grounds for departure. There are some grounds for adjustments. I factored them in. This is what the guideline sentence results in. I don't like that sentence.
For this case. And for that defendant.
I want to do something about it, but I recognize that there are no appropriate grounds. in which he basically was saying, will you appeal if I downwardly depart? Now, Jerry's point that we have all the discretion here and it's up to the individual prosecutor, I think is really somewhat of a distortion. We have very
That's
strict...
not the perception of most lawyers that operate in that system.
I think you think you have distorted it, because we have very strict guidelines within the office of trying to apply the guidelines even-handedly. And for instance, it would not be appropriate, and no assistant in our office would decide, for instance, suppose you have a case where someone has 50 kilos of cocaine, and on the sentencing guideline grid, that results in a particular sentence. No one would say, in order to get a plea, well, we're going to pretend there's only 10 kilos here in order to get the plea, and therefore we'll only present to the judge that there's 10 kilos involved in this case. So, I mean, there's
Matt,
some...
is there more flexibility pre-indictment, before you indict? In other words, during an investigation stage?
There's some play in the joints here, which I don't think is a bad thing, but it depends on the case.
I hear a yes from defense counsel, and I don't know about the judge.
Well, he doesn't want to say equivocally yes, but every day he's meeting with people and deciding pre-indictment whether it's appropriate to dispose of a case in a favorable way. The disparity is now determined behind closed doors. The disparity that the sentencing guidelines were put into effect to correct, the difference between a judge in Texas and a judge in Wisconsin, you know, that was in front of the world. Now the disparity takes place in the United States Attorney's Office, and their decisions on who to go to bat for, who to charge with what crime, who to say nice things about, and it's all done in nuances between defense lawyers and prosecutors. But the thing that I was talking about with Matt is a bizarre thing. If people could think about a federal judge appointed for life coming to an assistant and pleading with the assistant, say, I'm not comfortable with that sentence for this defendant. Please let me do it. Don't embarrass me by appealing.
On the other hand,
I mean, really, that is bizarre.
Congress, which of course is elected by the people, have made certain determinations on what appropriate sentences are, and they've done this through the Sentencing Commission. And they've determined that for a particular crime, and I forget what the crime is here, but suppose it's a particular white-collar crime, an embezzlement or something, that the appropriate guideline range for this serious crime should be a range of 2 to 3 years in jail. What right does a judge have to, by themselves, because for one reason they don't think bank embezzlement is as serious a crime as Congress does or the majority of other judges in the district, they decide that I'm only going to give 6 months for this sentence. And that is one of the problems that was under the old system. If you drew a particular judge in a case, even though it might be a serious crime, even though the majority of Congress, the majority of the people...
Let me interrupt for a minute. You're focusing on the offense, and I want to focus for a minute on the defendant.
Right.
I mean, I think that's a big difference. It's not that the judge says, gee, I don't take bank embezzlement seriously. It's the judge says, I'm looking at that particular defendant, and this sentence is wrong. Putting that particular defendant in a jail cell for 2 years under the circumstances of that person's activity, conduct, is wrong. And that's where the guidelines are harsh. When a judge knows with their experience and with their heart, and that's what you're a judge for, is to make individualized sentencing determinations, and the Supreme Court has recently affirmed that we have to make individualized sentencing. Well, individualized sentencing is hard to do when you're trapped in a guideline range, which is why I want to just make one quick point. I want to see the most advocacy I can from defense counsel. I don't see enough. I have to tell you, Jerry, we have to see more and more advocacy from defense counsel. And I've told Matt that one of the things I'm most frustrated by is the plea agreement sentence that forbids you from arguing for downward departure.
That's another thing.
What's a downward departure?
Okay, let me...
That's the fifth time.
The guideline calls for a sentence
Okay,
between 24 and 30 months.
Right?
In order for the judge to give less than 24, which is the minimum in that guideline range, the judge has to find a reason to depart from the guidelines, to go
and you can
underneath.
depart up or down.
Right.
And the way you do it, if you say that there's an aggravating or mitigating circumstance that was not considered by the Sentencing Commission, you have to say that. You have to say this is an atypical case outside of the heartland for that crime.
One thing that should be clarified, Jerry's point that the prosecutor has the sole discretion on departures, that's only in the issue of cooperation.
That's right.
There's a whole range of possible departures, upward and downward.
You don't allow people to plead in your district, often, unless they waive their right to argue for
To
departures.
argue for it, but see-
And that's another thing. Here's a defendant who's faced with a possible draconian sentence, doesn't want to go to trial, wants to dispose of the case by plea, and the prosecutor says to him, okay, if you want to dispose of the case by plea, you have to now sign an agreement that you won't ask the judge for any departure.
But I must
and
give,
you won't appeal.
I must give my footnote here. However, the judge can still depart. Just because the defendant doesn't ask for it doesn't mean I can't do it. But who's punished here? The judge. Why? Because I have to sit up all weekend finding a way to depart without Jerry's help.
Exactly.
He could have written a brief telling me how I could be creative and find the departure. He was a stop from writing the brief. I have to do it on the weekend.
Because the prosecutor has the power to not allow a defendant to plead guilty without the defendant waiving his right.
Again, that's really not right. I mean, we have plea agreements which are bargained for agreements, arm's length agreements between the defense and the government. And the agreements that you're talking about, often what happens is the government gives up the right to argue for certain upward adjustments or departures.
And we'll continue this right after the break. You're watching Lawline. I'm Alan Schnorman, your host. Stay with us.
In a life-threatening emergency, you should know what to do. Say a loved one exhibits unusual symptoms. The first thing to do is... Clear! No. The first thing to do...
Oh! Tourniquet!
No! The first thing you do is pick up the phone and dial your emergency number.
Call 911 first.
Right.
How about mouth-to-mouth?
I don't think so. To learn more about life-saving techniques, contact your Red Cross.
Your approach is looking to cover.
The men and women in the National Guard and Reserve face some tough challenges when they serve. Challenges that teach them discipline, leadership, and technical skills that make them better employees. So when they need time off to serve, don't make their toughest challenge approaching you.
Math, a four-letter word, right? Hey, you don't need that.
Why design the world's newest jets?
When you could be flipping the world's oldest burgers. Hey, wait a minute. This is math. Geometry, algebra.
No pocket protectors here.
But you're cruising without math. Yeah, right. Take a good look.
That's math staring back at you.
It's not a problem, man. It's an answer. Call NACME. We'll tell you what you need to do.
Hello, you're watching Lawline. I'm Alan Schnorman, your host. We're talking about federal sentencing guidelines. Our guests are Judge Shira Shinlin, United States District Judge, Southern District, Matt Fishbein, Chief Assistant United States Attorney, Southern District, and Jerry Lefcourt, President-elect, National Association of Criminal Defense Lawyers. Matt, what I don't understand, and perhaps you can help me with this, let's assume we have a hardened criminal, a gangster. I mean, this guy may have murdered, pilfered, usury, you name it, he's done it. And he's in the position to give up a lot of people, cooperate for years. And then, as opposed to the person who's done one crime by himself with no connection, who can't help the government because he's got no one to turn in but himself. So on one hand, you can make a lower sentence because of cooperation over a year's period, and the other guy has nobody to give up. How is that? How do you justify that?
Well, I mean, the justification is that oftentimes the way that we're able to make cases is by getting the cooperation of people who are themselves involved in criminal activity. And this is something which has existed.
These are bad people.
Oftentimes they can be very bad people, but if you expect to make a case against a John Gotti, for instance, you need someone like Sammy Gravano, as evil and vile as he might be, in order to give you the evidence which you might not otherwise be able to get. And the system, even before the sentencing guidelines were adopted, rewarded people for cooperating. And I think Judge Shinlin will acknowledge that even before there were 5K letters, which is what the term is for the government making a motion for a downward departure, judges gave strong consideration to people who cooperated. And it's always been a consequence of the system that if you are a person who's low on the totem pole and you don't have a lot to offer in terms of cooperation, you can't benefit from it.
But I will add one thing. It's very important to scrutinize the direction of this cooperation. One thing I've been offended by is if the cooperation, if you'll forgive the phrase, is down. I don't like to see somebody more important on the ladder giving up some little guy. It has to be up.
Yeah.
And you understand that if somebody is testifying against somebody more important, they're at risk. I mean, they're taking on a lot of personal risk for themselves and their family. So they deserve a reward, even though I understand the point of your question. Hopefully this littler fellow that you referred to, who had nobody to give up, also had a much smaller guideline range.
Yeah. And often will.
Well, likely he, in a drug case, he won't. I mean,
Jerry,
he will have the same guideline range.
I've heard stories of people who are white-collar crimes getting enormous sentences. One time they've departed, whether it was some sort of fraud that they were involved in or whatever, getting huge sentences with absolutely no discretion on the part of the judge. And you know that there's something wrong with this.
Well, one of the things that the guidelines has accomplished is a massive inflation in sentencing. The sentences now, under the guidelines for conduct, 5 years ago that could have, or 10 years ago, could have resulted in probation, could now easily result in 5, 8, 10 years. And that does not mean parolable offenses. Parole has been eliminated. So people get an 8-year sentence or 10-year sentence, they'll serve all but 15%. And it's really a long, long time. And people in the country have no idea how high the sentences have gone, even for fraud and offenses where there's no violence and no chance of recidivism.
Judge Shanlon, it's been reported that there's been a senior judge who was so taken aback by the sentencing guidelines in drug cases that they decided not to do any drug cases anymore.
That's right. I think there are several. I think there are two things to tell you. There are several senior judges who won't take drug cases, but there are several active judges who left the bench because they will not impose the draconian sentences required in certain instances under the sentencing guidelines. And when I say that, I'm limiting myself pretty much now to certain sentences in the narcotics area where we are bound to give the sentence based on the quantity of drugs. And there are mandatory minimums in the 10-year range based on quantity, even though the individual may have had a very minor role. It might be a first offense, but if he's involved with a group where the importation was 5 kilograms or more, he's going to do 10 years no matter who he is. That's what I said before, focusing on the offense rather than the individual.
And the other, just to point out, that person could have, as a young person in the state court, pled guilty to get rid of some other drug offense, and now he's the second time, and he's facing a mandatory minimum of 20 years. And that means actual time in jail, 17 and a half years. And so when you're facing 17 and a half years, which is not uncommon, and a prosecutor says you can only get out, well, your lawyer says that the prosecutor will only let you go lower if you give up people, the consequences of people saying anything to get out of this is a fallout of these guidelines and mandatory minimum sentences.
I obviously have a different view of that. I think one of the benefits of the guidelines is that it has very much induced cooperation, and I think that's a good thing for the system.
Some of it's not truthful cooperation.
Well, except the system is available to ultimately test that, and our office is very careful in who we sign up as cooperators. We sign up people only after we've tested what they've had to say to us and we've only been telling us the truth. And ultimately, there are people like Jerry Lefcourt here who are going to cross-examine them in court, and they're going to be held before a jury, and the jury's going to determine whether they're believable or not. And it's a rare case that conviction is going to be based only on the testimony of a cooperator without corroboration. So the system is still in place to test your theory here that people will say anything to get cooperation agreements. And the fact of the matter is the public has benefited immensely from the cooperators who have come forward, who never would have come forward in the past, and come forward now because, in some ways, the only way they can get a departure and the only way in some cases they might be able to avoid jail is to cooperate with the government.
So the plea bargaining that goes on in the state court does not go on in the federal court to any of the same extent?
Not with the court, but between the prosecutor and the defense lawyer.
It goes on. It's just on a different claim.
The court has no role in that.
Instead of charging you with
racketeering,
this crime, I'll charge you with
mail fraud.
No, it's in our office, and I can only speak for our office. When someone cooperates, our policy is that they plead not only to the conduct that we knew about, but any conduct that they've admitted in the course of meeting with us to determine whether we're going to sign them up as a cooperator. So if someone comes in and we get them on a drug offense or whatever, in the course of that they tell us that well, gee, it wasn't just the 5 kilos you know about, it was 50 kilos, and I also robbed a bank, and I also did this. They plead to charges which encompass all of that conduct. All of that conduct and the guideline range that results from that additional conduct comes before the judge, and the departure starts at that much higher level.
Is it that first you plead, then you cooperate, then you get sentenced? Is that how it works?
No. You first you indicate a willingness to cooperate, and you might meet with prosecutors on a number of occasions and with agents on a number of occasions before we decide that, in fact, you're someone who we believe is telling the truth and we think will render substantial assistance. And at that point, you enter into a cooperation agreement and plea.
And then there's that plea, and then they write this letter telling the judge to depart, but nobody knows how much the judge is going to depart. Some judges will depart to 5 years, some to 2 years, some to 10 years, so there's still a difference in which judge, I think,
Judge,
the person appears before.
As a personal thing, growing up, I always remember the Bill of Rights and the Bill of Rights and all the things that they told me when I was a youngster, how the Bill of Rights protected the individual, and everything was the individual. And there are two things that I feel that, first of all, double jeopardy. I remember growing up as a student, always remember, if you're innocent and convicted, a jury says you're innocent, that's innocent. Are we moving away from that more now?
Well, you'd have to say that the recent Supreme Court case that came down a week ago, which lets us take acquitted conduct into account in sentencing, moves away from that a little bit. I mean, here's a jury saying, not guilty, acquitted, and yet it becomes relevant conduct under the guidelines if the judge, based on a different standard of proof, preponderance of the evidence as opposed to beyond a reasonable doubt, thinks the person did it. If the judge says so beyond a reason, by preponderance of the evidence, the judge can consider that conduct.
And give a harsher sentence.
Right, but of course it's still the maximum sentence for the crime for which the defendant was convicted.
Judge, if you could speak to the legislature, if there were congressmen,
Oh, I'm so glad you asked me.
congresswomen,
Stop! Crack cocaine. Let me explain. This is the one. Very quickly. Powder cocaine and crack cocaine are treated completely differently by the guidelines. We have quantity-based sentencing, and the quantities of crack cocaine are treated, is it
100 times.
Thank you, 100 times more harshly than powder cocaine. And a lot of judges are very troubled by that, and they say, why? So the Sentencing Commission recommended that Congress do away with that. Did Congress follow the Sentencing Commission? No. For the first time, it rejected the Sentencing Commission's recommendation to stop that disparity between powder cocaine and crack cocaine.
Jerry Howard, what would you tell your congresspeople?
I would tell my congresspeople that the guidelines are very unfair, that they work a lot of injustice, and that the judge's decisions should be returned to, that the guidelines should be advisory, and no more than advisory, but that the judges should have the ultimate power to decide, based on who the defendant is and what the actions were, what the appropriate sentence should be.
Matt?
Well, just
in the cleanup spot, I may add.
Right. Just one response to Judge Shinlin. I think this really it says what the issue is here. Who should be making the decision? We may all individually disagree with the crack guidelines, but the question is it Congress's role to make that decision or an individual judge?
Okay, Matt
the Sentencing Commission.
Matt Fishbein, thank you very much for appearing on Lawline. Jerry Left Court, thank you. And Judge Shinlin, thank you very much for appearing on Lawline. This is Alan Schnorman. As always, thank you for watching Lawline.
You have been watching Lawline with your host, New York trial attorney Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions about this week's program, please write to Lawline, 63 Wall Street, New York, New York, 10005, or call area code 212-432-9111. This program was made possible by the law firm of Zalman and Schnorman, whose practice is limited to personal injury and insurance law.